I will start with the first slide, which is dispute resolution. Can I use this? Okay. In a very, very simple definition, most of you can get it from Oxford Dictionary, is a dispute just means an argument between two people or groups or countries, and discussion is held about a subject on which people disagree. An argument, basically a dispute. But in the real life, you understand that dispute is more than just this basic definition. It involves what they call commercial dispute, employment dispute, emotional dispute, relationship dispute, even geopolitical dispute, war, all these things. But just for today's purposes, just have a simple definition of what is the meaning of dispute. And the non-usual way people know, well, quite the non-formal ways of solving dispute is, well, you just bully the person until the person submit. To the extent that there is a resolution of the dispute in favor of the bully. And sometimes use physical violence. And nowadays, I think very common now, people go to war. You may think that war is the thing of the past. But for all you who knows what's going on in the world, it is a reality. And people do use war to try to solve a problem. But of course, we all know it's not the best way. All right. But now, in the more modern times and in the more formal setting, we have this kind of mechanism to resolve dispute, which you are quite familiar with, right? And this is what I will use a term called litigation for those who go to court. And arbitration, of course, you're very familiar with that. And more recent one in the last 10 years, adjudication is very popular. Negotiation is also a form of how to resolve matters. And of course, mediation is the subject matter of today's talk. I will focus on mediation, but I will just give you a brief comparison between litigation, adjudication, and mediation. And in litigation, I think as you know, it is a case where the defendant is forced to go to court. So you summoned the person. There's no such thing whether you like it or don't like it. You have to go. And it's very formal, and you have usually the rules of court. And this is where you need lawyers to what I call to represent you in court, either for the plaintiff or for the defendant. All this I think you are familiar with. But is this one that I would like to emphasize that in litigation, and quite similar to arbitration, the focus is on evidence and the law. What does the contract say? What's that section 7 of the contract says? All these are things that your lawyers will be focusing on. We call it rights-based form of dispute resolution. So bear that in mind, that is what the litigation about. Of course, at the end of the day, you have a decision by the judge in full public gag. Okay, you all know when you go to court, it's not a private matter. But sometimes you heard the words, don't, what they call, show your dirty linens in court, right? In public. This is what will happen in a litigation. And of course, the winner will be awarded cost, and it is a win-lose situation. Arbitration is quite similar, as the only difference is that it is semi what I call formal and private. You all probably have experienced that. The beauty about arbitration is that it's private. And the arbitrator is somebody which is appointed by you. All right? And the same thing arbitrator will have to do is listen to evidence and arguments. And I'm sure those of you who attended arbitration before, the volume of documents your lawyers have to produce can be from corner to that corner, which I did once before. It's an international arbitration. It's that long because you cannot leave out any documents. Otherwise, your clients will say, look, how can I never tell this to the arbitrator? All right. So, but at the end of the day, it's still a win-lose award. So in that sense, the litigation and arbitration has one important feature, or similar feature, I will use it. It is a decision made by the judge or the arbitrator, which is binding on the parties, and it's a win-lose situation. All right. Okay, the next one, which is more modern, is what we call adjudication, which you're very familiar with. I think many of you have even have this new terminology used in town now. I sipa you. Very common words now. It become a verb. So you're gonna sipa now. But this is something which I think you're familiar with, and it came out in 2012. I think you know the purpose of today. I will not go into it, but basically it deals with claims under a construction contract. Very specific for the construction industry. So does it apply to hire purchase or other things? Then advantages, of course, is speedy, but it's also binding, except that it is final but yet not final. I think you know what I mean, right? Because when you have arbitration after the adjudication, the arbitrators or what can the way vary your adjudication decision, right? So that is adjudication for you. I will not go into so much detail of adjudication, but I think today I want to focus on mediation. Now, is mediation something that is very, very new? No. If you go back to culture, history, people have used mediation in one form or another, except that we probably it's not called mediation. Even the Islamic culture, you have the, in Malaysia, the pemulu or they say, which have been doing that, right? And then in the Chinese culture, you have the client association. All these are people who are functioning and performing the role of a mediator, right? And sometimes, especially during the what we call the colonial days, where a lot of Chinese migrants come to Penang or Malaya at that time, you have client association who will resolve dispute. They may resolve it in quite a very forceful way, like sometimes, all right? Take it or leave it. But some form of mediation there going on. Of course, Hindu also have their own, the panchayats. So it's not something that is totally alien to our culture. But what is happening now is we call it a modern form of mediation, which can be done in a more systematic way and effective to achieve the result, which is a settlement between the two parties, the two disputants. Okay. Let me just do a simple exercise, if you don't mind. All right. This is called cross the line. And simply, it just want you all to exercise a little bit, stand up, and just do a simple, and follow this exercise. To do that, I will ask you to break into two groups. Very simple is A, B, A, B. So you don't mind, we start with A, B. A, B, A. Got it? The last group? Everybody got it? All right, very simple one is A on this side and B on this side and form a row. This is a boundary, huh? A, one line, B, another line here. And if you don't mind, help me please move the chair to one side. Maybe bring the chair back again. All right? That's all. A on my left, one row, and B on my right, one long straight line in the middle of the hall. And you help me by moving the chairs to one side, and we will bring the chairs back again. So those are A on my left. Those are B on my right. B on my right, B on my right. And then you just face each other. B on my right, A on my left. and have a partner in front of you. All right, you follow this line, huh? This table line and this table line, that's all. One line here, please. One line, one line. Those on B on my right, B on my right. Okay, B A here. Hello, how are you? This one right here. All right, get a partner in front of you. You must have a partner in front of you. All right, get a partner in front of you. I'm missing anybody? There's one space here for B. For B, anybody B here? One space. Everybody got a partner? All right. Get a partner, okay? Ready? All right, ready, huh? Get a partner. What you need to do? What you need to do is the objective is to get your opponent to cross over to your side using non-violent means. To get your opponent onto your side. I repeat, this is one side and this is another side. So get your opponent to cross over to your side. All right. And you don't need 5 minutes, I give 1 minute only. And rule number 1, you win when you can get your opponent to cross over to the other side. Let's start. You only got 1 minute. You win if you get your opponent to cross over to that side. You got 20 more seconds. You win if you get your opponent to move over, to cross over to the other side. You got 15 more seconds. 15 more seconds. All right. Stop. Stop. Don't move. Anybody move? Raise your hand. And some of you did not move, right? So you move, right? Who win? Who win? Both win, right? You move. Who wins? Both win. All right. Stay on the line. A and B, same B and whatever. This line, just keep this line and get opponent. The next rule, we're going to change a bit, change the circumstances and change the narrative. And the narrative is you lose when you cross over to the other side or you remain stationary in your position. I change the narrative. Hello? You lose when you cross over to the other side or you remain stationary in your position. You have this one, you have 2 minutes to negotiate. You can negotiate, you can talk, you can persuade, you can coerce, but no physical violence. Okay, no physical contact. Ready? 2 minutes, huh? Start. You lose when you cross over to the other side or you remain stationary in your position. You got 1 minute and 30 seconds. You can negotiate, you can do this, you can persuade, you can coerce, but no physical violence, no physical contact. You got 1 more minute. Let's try. Drag ahead. Look at each other and try to think of a way to solve it. Up to you. As I said, any way you want. Any way. You will, remember, you will lose if you remain stationary. Okay, time's up. Don't stay on, stay put, stay put. What happened to you? Where's the partner? He's not in the middle. So who win? Did you cross the line? So do you lose? No. Hey, what do you happen? Oh. How? How? Huh? How you do it? Yeah. And so both of you are in the middle. All right. Okay. Go back to your seats. Go back to your seats. Thank you for this cooperation from you all to carry out this exercise. Okay, settle down. Okay, I hope you had some bit of fun. As you can see, the first one, the first rule, you win when you get your opponents. And so quite easy, right? Everybody just did, and it's a case of win-win. Second one is I change the narrative, you lose. So some of you did not move at all. All right, both you lose. But there's one group who moved, a few groups, I think, who moved to the center. Which group was that? Which pair, right? So, do you lose? Do you win? That's right. But the creativity is that you're able to think out differently to achieve a situation where neither party is lose. The first is both party win. Second one, neither party lose. So bear that in mind, because that is what we hope to achieve, a win-win situation where nobody loses. All right. So the next part of the lecture is more of the subject matter itself. What is mediation? You know? So in what we call in a nutshell, again, in a very simple Oxford dictionary, is an attempt to end a problem between two or more people who disagree by talking to them and trying to find things that everyone can agree with. So it means involvement of a third party to try to resolve and talk to them so that the two parties, the two disputants, can come to some kind of an agreement. All right. Now, in the mediation model that we are promoting, we meaning myself and including the Bar Council and my Malaysia International Mediation Center, even the AIAC, the Asian International Arbitration Center, of which I'm a mediator. We have a few models of mediation. Today, I'm going to share with you so that you have better understanding. The usual one is what we call evaluative, and the second one is called facilitative, and the third one is called met up, which some of you may have heard before. Now, the evaluative mediation is a case where the mediator is authorized by the parties to give his views and opinions on the strength and weaknesses of the case. So the mediator usually has a substantive understanding of the subject matter. For example, if it's a case of maritime dispute between the shippers and what I call the cargo owner, you get somebody who is good in maritime law or construction for that matter, architects, engineers, to be the mediator who has subject matter because they know roughly what is it. Reason is this mediator is authorized to give his views and opinion, which is valuable to resolve the dispute, right? And the evaluation is based on usually industry practice. Here, the mediator also assists the parties to evaluate the cost of certain action. For example, you want to go to court, the mediator will assist. Or you want to get what I call another contractor, but this is developer said, I think I want to get another contractor to take over this job. Fine, there's one option. But this evaluative mediator will go through with the developer to assess the cost implication of it. In a sense, a neutral way, because it's a third person. All right. So this is one form of mediation. And in the real life, evaluative mediation is done on a shuttle mediation basis. Why you call shuttle is that the two parties, disputant A and B, instead of meeting together in front of the mediator, they are met separately. Mediator meet with A first, in absence of B. Talk. What's the strength, what's the weaknesses of this thing? Because in the course of talking about the weaknesses of the person's case, you don't want your opponent to hear. But because you talk to me about your weaknesses, I can tell you, see, really you want to claim 1 million, you cannot. So maybe try to reduce it. I can say to you in private. At the end of the day, I'll mellow you down from 1 million claim to probably more realistic one, 400,000. That's not to be. You okay? I don't want to pay him because he cheated me. All this thing, blah, 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 blah. All this thing come. You want to hear all this. You want the other side to hear. So what we call is A, B kind of a method of trying to get a party to resolve, because a third party heard two sides. And eventually they come together and say, look, there's some proposal for settlement, 400,000. He said, no, I still want, only can pay 100,000. So the gap from 1 million is now reduced from 400 to 100,000. Then talk again. But why you reduce, you know the reason. So the mediator have told you and assess with you, A can, B cannot, C cannot. And then you become more realistic. So that is what we call an evaluative mediation, where the mediator gives views and opinions. And okay, of course, the advantages is that it can, where the issues are more legalistic and more factual finding. This may be suitable for those who want to do evaluative mediation. And where the future relationship between the parties is not essential. I mean, just one off thing. For example, this is actually very suitable for accident cases, running down cases, where the plaintiff injured all this thing, and the defendant is usually said, I'm not liable. You're the one who caused the accident. The defendant said, no, I'm not me. So who's right, who's wrong? And then at the end of the day, how much to claim? So evaluative mediation will help to talk to the parties. Accident, sometimes you partly your fault, partly not your fault. Eventually, you may even get a party to say, yes, both are at fault. But the next question is, what is the percentage? Plaintiff only 20%. That's what the plaintiff will say. Defendant said, no, I'm only liable for 40%. So the evaluative mediator will assist the parties to go through this. Otherwise, he will go to court. And if you don't go to court, what will happen? Policemen will be involved. Witnesses will be called. Maybe even the picture of the cars, the damage all will be brought in. Very messy and can be a longer period. So if you thought evaluative mediation is faster outcome. Of course, disadvantage is that it can be too much focus on legal rights and no creative solutions. I will come to that. What do you mean by creative solutions? Which is more effective in another kind of mediation, which we call facilitative. Facilitative mediation is the process by which the participants, together with the assistance of a neutral person, systematically isolate disputed dispute in order to develop options, consider alternatives, and reach a consensual agreement that will accommodate their needs. In this concept of facilitative mediation, it's the case is a situation where neutral person, the mediator, will systematically isolate. So the word systematically isolate means there is certain structure, certain methodology to achieve that. And to develop options, consider alternatives, and reach a consensual agreement. This is what the mediator objective is, to reach a consensual agreement that will accommodate their needs. It's not rights, needs. You'll find that a lot of situations, what the parties want is more than just what the contract says. Because there are many other issues that will come into play. So mediation methodology is aimed to achieve that. Go beyond the four corners of the contract. And it's suitable for most type and dispute where the solution is not strictly on the legal rights of the parties. And important is by future relationship between the parties is important. All right. Now, this is where the concern of the parties on commercial personnel are given due attention. A very good example would be, let's say, even your normal subcontract claims of between the parties, subcontractor and the main contractor, or vice contractor and developer. They're bound to be dispute. There's no doubt about it. But I think very common in your life, you try to settle. And usually, one of the incentive to get parties to settle between the developer and the main contractor is the prospect of a future contract. Right? That, okay, our public developer may say, look, okay lah, this coming project, I'll probably appoint you again. But please reduce your claim here. And what will happen? Usually it can achieve. This is what we call creative solution, which cannot be achieved in court. If the matter goes to court, it's straightforward. The main contractor will say to the developer, look, I've done this, you never pay me. And why are you entitled to claim? Because section 27 of the PAM contract Act says so. And then you start arguing what is a variation. Is it a variation order or is just what we call a modification, that kind of thing? That's where lawyers come in. At the end of the day, the poor judge have to make a decision. Yeah, it's a variation order, but cannot be so much. You know, how many days gone? How many witnesses have been called? But in mediation, it's only 1 day. And the focus is not so much of the details, it's let's be practical. You know, but the one of the incentive is what we call ability to appoint you in another project. And the beauty of a mediation is all this can be written down in a settlement agreement. In court, the judgment cannot have the judgment they get from the court. The plaintiff hereby agreed to appoint the defendant as the next contractor for the new project called Pamela. No way you can do that in court. Mediation, yes, you can do it in a settlement agreement. This is a very beautiful thing, important thing about mediation. The future relationship. So this is a key feature of mediation, which I think I need to emphasize, is that the mediator is neutral and does not make a decision. You may find it very strange. I have a quarrel with this person. I want to settle it. I come and see you, the mediator. Yet the mediator say, sorry, I cannot make decision. But I want you to make decision. I'm right. Or that you can solve it for me. Not immediately. They don't make decisions, but they have the ability and the skill to get the parties to arrive at a settlement on their own. That's why I call facilitative. To facilitate a settlement. You don't decide. And this is something I want you all to take hold. But how to achieve that? We can elaborate a bit more. Another quick explanation about another form of mediation is called MET-UP. MET is for mediation, UP for arbitration. You've heard it before. Arbitration, I think you know, you bring in all evidence, arbitrator makes a decision, and it takes on 4 days, 5 days, even months, depending on the nature of your problem. Met up means that you get the mediator to try to resolve by way of mediation first. And usually fixed for 1 day. Usually. And in the course of mediation, if done properly, and the arbitrator is also qualified, you find that you can resolve, let's say, 5 issues, maybe even 2 issues, or maybe even all the 5 are resolved through mediation. But the difference about mid-app is that in those 2 cases that you cannot resolve by mediation, you then go for arbitration. And you actually expressly tell the arbitrator, look, we tried, we resolved 3 of it, but we want you to go for arbitration and make a decision on that 2 issues. So it's a combination of both mediation and arbitration, and this is called met up. The only difference, or a caution here, is if it's the same person, I mean arbitrator who will be the mediator, the parties must be told. The parties must agree to this form of mediation. It cannot be a unilateral imposition by the arbitrator by saying that, look, I think I'll start with try to get your negotiate and settle first. Oh, I want to settle everything. Tell me more about it. And cannot resolve, then become arbitrator. No, it has to be agreed by them. Otherwise, it's a breach of the duties of an arbitrator, and can be even be a challenge for misconduct. That is what they call form of mediation. And in short, these 3 types of mediation can be used in different circumstances and depending on your needs. And I want to share, just to say one point is, the lecture we're talking about today, although you are in the construction industry, principles applicable to all kinds of situations. I've done commercial contracts, dispute where I'm a mediator. I've done dispute between what they call the families in respect of estate, who's supposed to be the proper executor of the estate, the quarrel for 10 years. You know, and eventually we came before me as a mediator. We talk about it. Maybe I can share this with you. Very interesting kind of situation. In a case where the plaintiff is saying, look, I also want to be the executor. The defendant said, look, I'm the executor. And the reason why the plaintiff is saying I'm executor because I'm the second wife. You know? But the other side don't want to concede. So you don't concede, you don't recognize her as a second wife, right? In court. So you become argument whether she is the second wife. In the course of what we call the pleadings before the court, it actually lasted for 10 years. They even take pictures of the tombstone. That's the plaintiff. To show that her name was written on the tombstone of the husband. All this came before me. And can you imagine that if I were the judge, I have to go to maybe you pay a visit to see whether such a name was mentioned in the tombstone. But in mediation, they actually recognizes her as a person who has been in the house, who came to Chinese New Year, who actually interact with them. Children also interact with them. They recognize in the so-called customary way to the second one. Except that we go to court, they don't want to admit it. But eventually, the settlement was co-executed. Happily resolved and signed the settlement. And this time I share with you because at the end of that mediation session, around 5 something, we spent the whole day. The plaintiff daughter who was there came and told me, tomorrow is this coming Sunday, I will go to church. I will say some prayers and blessing for you for solving this case for us. That's the most beautiful thing I have ever encountered as a mediator. Able to help them to solve something with languishing in court for the 10 years. Because it's just talking to each other. So mediation really applies in all sorts of situations. Now, just a short break from all the lectures. Let me share with you this beautiful slides. It's called Who is Rich and Who is Poor. Some of you may have seen it before. Let me read it. One day, the father of a very wealthy family took his son on a trip to the country with the express purpose of showing him how poor people live. They spent a couple of days and nights on the farm of what would be considered a very poor family. On the return from the trip, the father asked his son, "How was the trip?" "It was great, Dad." "Do you see how poor people live?" the father asked. "Oh, yeah," said the son. "So tell me, what you learned from the trip?" asked the father. The son answered, "I saw that we have one dog and they have four. We have a pool that reaches to the middle of our garden and they have a tree that has no end. We have imported lanterns in our garden and they have the stars at night. Our patio reaches to the front yard and they have the whole horizon. We have a small piece of land to live on and they have fields that go beyond. We have servants who serve us, but they serve others. We buy our food, but they grow theirs. We have our walls around our property to protect. They have friends to protect them." The boy's father was speechless. Then the son added, "Thank you, Dad, for showing me how poor we are." Isn't perspective a wonderful thing? Makes you wonder what will happen. Then you have a situation, better. Then you have a situation where you can achieve a settlement. Like one group, one pair went to the middle. Some of them did not do anything. Don't know what to do because I changed the narrative. All right. So this is what I call perception. All right. Now going to the formal part of the lecture in the sense of mediation. I give you some ideas what mediation is, but as I said, it must not be done in a haphazard way, in a very what I call like a pasar malam kind of situation. How much you want to give? How much you want to give? How much you give? We are promoting a form of mediation where it's structured. And the structure assists, and the structure, sorry, some people don't have the ear problem. And the structure is such that it makes mediation an effective tool to achieve a settlement. The Bar Council done mediation the last 15, 20 years. The success rate, those who go for mediation, is about 70%, 75%. I myself also done it. It's also about 72, 73% success rate. And in Singapore, and in fact, other countries where mediation is a big thing, it's as high as 85% success rate. Meaning to say that dispute. Hello? Yeah. So negotiation, in fact, it also happens between the developer and the contractor and the subcontractor. It happens in all the way. So it is like a given fact because nobody wants to dispute all the time. But sometimes cannot resolve. This way, the usual way is court, a third party or arbitrator. But we are providing an alternative. The third party is the mediator. So so it's one way to resolve dispute. Now, I'm moving to this one, model of mediation process. Okay, can I? In a workshop that we also train people to become mediator. We are proposing this model in a sense that a mediation involves various stages, and the qualified mediator must be able to understand these stages to be an effective mediator. Otherwise, he cannot pass. We cannot pass him or her. So we do have a pre-mediation meeting where we talk about it. And after that, we have a mediator statement. You never see it in court. The judge will never say, okay, let me say something about the case. What happened in court, for those who have been to court, very simple. The interpreter will say, bangon, so everybody will stand up, right? Then we bow, and then the judge sit down, and other parties sit down. Then the first person who speak will be the plaintiff lawyer. My lord, I mean, so-and-so represent the plaintiff, and Miss Shida will represent the defendant. And my client's case is a case of claim damages or sexual harassment. The lawyers start talking in court, and same also in arbitration. Mediation, the first person to speak is the mediator. I'll explain to you why. After that, then we have what we call parties opening statement and summary. Summary actually means the mediator summarize what the parties have said. Never happened in court, right? Because by summarizing what you say, I then understand that this is what you want, where you're coming from, you know. Then we have what we call identifying agenda setting. Agenda setting is a very important part of mediation. It may sound a bit awkward, but basically means that, okay, you want to talk about what they call defects. You talk about suppliers not able to what they call deliver on time, and then talk about damages. We talk in a systematic way. That's why agenda. And finally, we have exploration of issues, and we talk more about it. What is very different from litigation, arbitration, and mediation, on the other hand, is private session. Meaning to say that the mediator meets the party in private in the absence of the other side. And the reason for that never happened in and cannot happen in arbitration or litigation. Then we talk about negotiation and then agreement. So it's all very structured. Sorry, I hope you all remember. Yeah, our answer is this. It all depends on the party's need. For example, if the matter has already gone to court, and sometimes the party has to go for mediation, the mediator of court. It means that the parties have already have a lawyer. And we encourage them with the lawyer because mediation tell the lawyer to get out. The judge only want to see the plaintiff and the defendant. And poor plaintiff and defendant don't know what to do, don't know what to say. It's natural for human being not to be comfortable with a third party, a judge. No, I'm so used to my lawyer. So we do encourage lawyers. But there are many kind of mediation where I didn't go to court yet. But it's just started up by husband and wife, no? And they can go for mediation without a lawyer. No problem. That is one of the beautiful things about mediation. It's flexible, up to your needs. Hope I answer your question. So, okay. I guess I'll go briefly about the various process so that you better understanding. Pre-mediation means before the actual mediation session. We want the parties to come because most of the time they don't know what mediation is about. So this is an opportunity for the mediator to explain the role of the mediator, the features of mediation, features meaning the egg shape that I presented to you, and what I call it, and then to have an execution of the mediation agreement. Now, the features of what I call the role of a mediator is something that most members of public don't quite understand. They think that the mediator is there to make decisions. So very often we emphasize that, look, I'm here as a neutral person and I'm here to assist you to come to a settlement. I'm not here to make decision on who is right, who is wrong. No? This one is something to be done by somebody else. But we have the ability to get you to arrive at settlement. Very clear. So that they have I will call it the right frame of mind to enter into a mediation session. The other equally important thing is agreement to mediate. Why? You will know at the back of your mind that when you go to mediation, you also talk about settlement. In the course of giving settlement, you also sometimes feel that, am I giving too much of my case? Am I showing my weakness to the other side? Invariably, there will be some discussion along that point. But all this communication, discussion, even offers of settlement are confidential and cannot be used in court. This is very important protection for the disputant in a mediation. And that protection, where it's confidential and cannot be used in court, is found in the mediation agreement, agreement to mediate. Express clause for that. So parties cannot run away from it. And secondly, I will talk about later, that we have a mediation act, an act of parliament, which also expressly talk about that. So you feel free to talk, feel free to negotiate, feel free to offer and come to a settlement. The last one, which I just want to emphasize, is authority to settle. This, again, usually when I talk, I ask the parties to fully cooperate with me, the mediator, on this point. The person who come to settle come to mediation, must have authority to settle. Simply because it's meant for one day and to achieve a settlement. Can you imagine it's a company who just send their what they call senior executive to the mediation? What can the person do? Probably he knows some facts. By the end of the day, I think we should resolve it this way, no? Okay, we take 30,000 and the next cut, next, I will give you another increase in your purchase. All this. That poor girl or he cannot make decision. So the whole day wasted. So we emphasize that the person who attend mediation must be someone with authority to settle, including what they call even the general manager, even director, even CFO, or if it's a manager, we do one more step. Please get a letter of authorization from your company in black and white, saying you have authority to settle and attend a mediation. Otherwise, it's a waste of time. We have done it, we have seen before where people just listen for one whole day, cannot make decision. What's the point? Right? So, and then of course, just to show you, venue and time, all this thing is very flexible for mediation. I've done it where we held in the hotel boardroom. Nice environment. And then we organize tea breaks and lunch in the hotel. Of course, all this is paid by the parties, but very nice environment. No problem with that. Okay. So in the pre-mediation, that's what I mentioned just now. What I mean by mediator's opening statement. So in the pre-mediation, you fix the date. It could be 3 weeks time, could be 4 weeks time, but a mutual date, and you finalize the venue of this thing. So when this is where mediation starts, when the work go, the mediator is the one who made the opening statement. And usually it's like this. Thank you, Mr. Tan and Encik Ali, for coming to this mediation process. I am very glad that you are willing to choose mediation and resolve your dispute. I'm here as a mediator. I'm here to help you to resolve the dispute. Although I cannot make decision on the thing, but I have gone through the various training to be able to assist you. Here, we're going to start off with parties opening statement. And then after that, then we will give you a chance to speak to each other. What happened is I'm setting the When you say it, you must say it with authority. Okay. Doing that, you gain the trust of the disputants. Nothing like that. Disputant telling them somebody that they can trust. Listen to my story. In the mediator, listen and help about it.
Hello. Hello.
How to resolve it. All right. And it's, in fact, in my own experience, I will make one statement like this. This is a voluntary process which you come. If at any time you feel that you do not want to continue with this mediation, you are at liberty to terminate this mediation. Expressly tell them that, because the emphasis is the party's process. But we have a way of doing it, as I said now, as trained mediator, to make sure that continue until the end of the day. So the emphasis that it is a party's way solution is so important. All right. We have this feature, which again not common. We call it the party's opening statement. What mean by party's opening statement? We actually ask, Mr. Tan, can you please tell me in a very in less than about very short, why are you here? What is it that you brought you here? We want to hear from you. In court, it will be the lawyers will do all the talking, and the lawyer's presentation of the facts and of the issue is very, very different, very legalistic. But coming from you, and especially they said, let's say family dispute, you will go say, yeah, I don't know, well, my wife, she's terrible, no? She nag me all the time. That could be the opening statement from you. For us, mediator, oh, okay, good. I know what you're talking about. What is bugging you? The emotion that goes with that is equally important, especially to a family dispute. And maybe next time you ask you, okay, thank you very much for having told me about your story. And this is, I'll say that you find that your wife has been telling you a lot of things. You don't. You also told me that your wife claimed that you spend too much money. That kind of thing. You also told me. So we summarize it. One, you heard. Let me hear from you. What is it that you brought you here today? He cheated on me. You know, he told me that he went for golf, but actually he didn't go to play golf. But what is happening? Is that this could be actually the thing that actually bugging them. Not the case of whether the marriage has been broken down irretrievably in the eyes of the law. Not the case of whether the custody of the child should be mine or not. There are many other issues. Yeah. So parties' opening statement is so useful to a mediator because it talk about concerns of the party. And in when that kind of session, the mediator will actually engage with the disputants. We actually have eye contact, very important. And we even say things like, okay, I hear you. Yes, I think so. Must acknowledge the person. Oh, okay. Okay. What does it happen? You don't know what the judge of that doing, right? You don't know. But here, very direct. Very, very important. We mediators even say things like, I see, Oops. I see. Go on. Okay. Very important. Okay. Now, agenda setting. As I say, to identify the issues both parties see as a problem. Identify issues one side sees as a problem. What happened is we actually ask the parties what is the thing they want to discuss today. And sometimes it's a case of lack of just don't spend enough time with me. So time. And maybe frequent trips overseas. So we list it down. And then children, education. The father, the wife is complaining, you lousy father, never even spent any time with my children. All right. So we do it in such a way that issues are identified. Because children, in that example which I gave, is one of the things that is bugging them. So we don't talk about how to address that. So the whole purpose is of this agenda setting is to resolve, look at things in a systematic way. You will find that when people quarrel, they talk about this issue, that issue, then they go back to this issue again. Then they go to the fourth issue, then go back to the second issue. Go round and round. Here, the mediator is to assist the parties to identify the issues in a systematic way. The other thing which the mediator is do and should do is what we call focus on the problem and not the people. All right. You did not spend enough time looking after the children's education. The focus is, what's the focus? You did not spend enough time. But the topic is children's education. Because you take away the okay then. Okay. 10-minute break and then we come back again. Now, what's the time now? 10:30, come back in 10:40. All right. Okay. All right. Thank you for coming back. I'm glad that hopefully you had a good break. Now the mic is better, but maybe a bit loud. You're okay with the sound? It's not too loud, huh? All right. So we can continue with this. Yeah. We were here about agenda setting, and I think basically I explained the importance of this agenda setting to basically to focus on the issues that the parties have. Now, the next stage of the mediation process involves what we call exploration of the issues, further information gathering, and talk about the needs and interests. And this is something that the mediator will allow the parties to talk. So, for example, even in the case of what we call the claims, architect's claim, whatever, against the contractor, against what I call the developer. Sometimes it could also involve what I call the design itself. So here we allow the parties to talk more about it. Because earlier before this, we just say there is some design issue. So this is a time for the architect to elaborate more. And say, look, I have already done the design. You are the one who asked me to amend it. You're the one, I've done so many changes for the 4 or 5 changes. And then I submitted it to the contractor to implement it. But the contractor didn't follow my design, so it's not my fault. Because the developer will say, look, because of your design and something happened to the construction and not done in proper way. and who is at fault. So this is the time where the parties will talk more about the issues that is before them. And at the end of the day, it could be very well a case of misunderstanding, but it may not be. So it depends on how the parties look at the issues. At the end of the day, we talk about needs and interests. Sometimes, in the same example, we talk about the architect's claim. Sometimes it's a case of the developer changing so often and want the changes to be done and completed within a short span of time. So the architect basically said, look, I'm not saying I don't want to accommodate your needs, but you give me too little time. And then the changes is quite massive. I need one more assistant to help me. So that's what we mean by, in the course of the discussion, you'll find that the needs of the parties. And it could very well be at the end of the day, the developer said, okay, I'm willing to pay you more to engage another junior architect to at least cover the things that I want you to do. So that itself is a form of resolution of the dispute in that example. But it's through discussion, it's through talking, understanding each other's needs. But of course, at the end of the, you also need to talk about feelings, especially when you talk about relationship issues, even employer-employee issues, sexual harassment cases, that kind of thing. And these are the things that you need to know. And the mediator should not shy away from this. Yeah, this one, please don't talk about this now. This is, when you talk about this, you get very angry. You know? Okay, I hear you shouting on this thing. No. We mediator don't say that. We just listen to you. We understand that you have this concern and this you're upset about this. We will talk more about that. So this is what happened in the exploration. Next part of the mediation process is what we call the private sessions. This is a time where parties can air their view privately without embarrassment in front of another. And to uncover the bottom lines. So you also have bottom lines where in the case of construction claim or commercial claims, usually there is a bottom line. I'm willing to give a haircut of so much, you know. But they don't want the other side to know. I think even in negotiation, when you do it without a mediator, there's always this fear of who's going to start with the offer. Who's going to start with the negotiation? Okay, the fact that I'm going to make the first move, okay, I'm going to reduce by 40%. That itself can be perceived as a weakness. And the other side may take advantage of that. But in the private sessions, we actually talk about that. So you can say to the mediator in private session that this is my bottom line. I'm willing to take 40% haircut on this and my claim for variation orders, that kind of thing. Because I know that certain things cannot be proven, and certain things not developer's fault, but some other people's fault. But please don't tell the other side that I'm willing to go for 40%. I would like to start off with 20% discount. So no problem. So the next session, what is on the table is only 20%. But the mediator knows that your bottom line is 40%. So when you talk to the developers, same thing will happen. The developer say, okay lah, I'm happy with 30%, but don't start off with that. Start with 15%. What happened is that somebody, the third person, knows that the bottom line of both parties. And the mediator will then work towards getting the party to be closer and closer. And this is where discussion, talking coming. And sometimes when we talk about bottom line and in the private session, it can also mean a second private session. It can even be a third private session. And sometimes I know the bottom line is 40%, but he's want to only offer 30% plus something else. Maybe LAD. Please waive your LAD. So you see or not? Oh, even worse, the other way. Okay, 50%. And instead of 40%, but you waive the LAD. Many combination. So this is where in a private session, you deal with all these what I call concerns. And at the end of the day, you want to underlying interest of the parties. What do we mean by underlying interest? It's very common in a construction contract where claim is not paid on time. And the contractor or subcontractor have cash flow problem. Especially if you have some other contracts, 2 or 3 other contracts elsewhere. So you want to resolve this fast. That's why SIPA came in. I think you all know the history of SIPA. It's meant to achieve that. But SIPA also takes some time. And it's actually a big improvement. But if the contractor knows, the mediator knows that I need cash because I'm going to start off a new contract there. I need easily 100,000 to kickstart. So in a negotiation with the developer, instead of asking for 300,000 immediately, maybe the negotiator, okay, I'll give you a haircut, 200,000, but pay me 100,000 first now. Then the balance 100,000, you can pay me in 4 installments. What's happening? The underlying interest of the subcontractor is dealt with. He got the 100,000 to start off another project. So this is where a mediator comes in, because in the private session, he knows all this thing. He knows what is bugging the disputants. And he helped the parties to arrive at a settlement. So this is what they call the mediators would do in a private session. Help the parties to generate options, evaluate offers, things like that. And including talking to the subcontractor, what if there's no settlement today? You told me just now that you need 100,000 within 2 weeks to get another project. If you don't settle, how are you going to able to get and secure the second project, the new project? If you go to court, what is your option? How long will it take? What's the chance of succeeding in getting 300,000 that you're asking for? This is what happened in the mediation. We actually do reality testing and test the parties, make them think in a practical way, but through a third party, a neutral person, an impartial person. Right? So there are few techniques that the mediator is trained to do. And one of the techniques, if I go speak a bit more, is what we call the reality testing. So sometimes you use the word playing the devil's advocate. There's just some examples of reality testing. What happens if the advocate refuses to amend his certificate? So this is all done in the private session. So what do you think are the other side's chances of succeeding? Sometimes you got to make them realize and think what is your opponent's strength, right? So you make them think. After a while, you'll find that, oh yeah, my opponent's case is not that weak. They do have some basis to counter sue me, especially things like LAD, late completion on this thing. Somehow or rather in construction industry, there will be bound to be some kind of contribution from the parties to the delay in the completion. And another technique we use is, I'm going to ask you to step into Ali's shoes for a minute. Basically, we use this technique. If you are the developer, would he really give you 300,000? Why would he give you? Make them realize that sometimes the developer have a reason not to give so much. All right. After all this private session, the next thing is come back. We call it the second. Okay. The second joint session. This is the time where we bury the past and look to the future. Very important. Otherwise, you go back to talking about the past. Then you talk about options, and then you evaluate. Options basically is ways to solve the problem. And there's few examples I give it to you. No, it's something that is where the mediator will have to emphasize. All right. So just to pause here to recap, the 8 model, which I call 8 model, is structured in such a way that it's meant to achieve an effective mediation process through various stages. And each stage has its own purpose. So we went through the mediation statement or participant statement and exploration, private sessions, and then the joint session. And you want second private session, a third private session, all very flexible. All right. So at the end of the day, you come to an agreement. The agreement is make sure that you cover all the issues. That's where the agenda comes in. There are 4 issues. Don't be so happy that you sort out the issues on LDD. Then you've forgotten about claims for defects, liability, that kind of thing. So make sure that your settlement agreement covers all. And if there's a lawyer, just to answer the question about the participant, if the lawyer is present, get your lawyer to draft the settlement agreement. Of course, if no lawyers, then mediators prepare. Why? Because that is the final document after you talk for 6 hours. So you want it to be written in such a way that it captures the needs and the what I call the desire and of the parties. So if they have a lawyer, get the lawyer to draft it. If you don't have no choice, then the mediators will have to draft it. I've done a case where we actually drafted it handwritten. Okay, because there was no lawyers. Don't be caught by the fact that it has to be formal, legalistic, and typewritten on this thing. All right. The reason is very simple. In the eyes of the law, an agreement signed voluntarily without coercion can be enforced even though it's handwritten. All right. So at the end of it, you get a party to sign the agreement, and mediator only witness, sign as a witness. And it's a legally binding contract. Do not, and this is something even if you are a disputant, even if you are a mediator, do not let the party go home unsigned, assuming they reach agreement, and let the party say, let me think about it. Let me go back and think about it. And you know what happened in real life. The bound to be changes. Right? And this is especially so you talk about matrimonial cases, kind of thing. It's very emotional. So husband and wife happy to settle, but when you go home, relatives will say something else. So one of the very important things we tell the mediators, we train them, is get them to sign on the same day. Right? Whatever form you have, including handwritten, I said handwritten. But believe me, if you do the mediation properly, you do it in the way that we call facilitative, you'll find that it is their solution. It is their settlement terms. And if you can achieve that, very unlikely they will want to challenge the settlement agreement. Okay, in my case, none of the settlement agreement has been challenged because it comes from them. And let's say one day settle. Of course, there are cases where it's not successful. I do have cases not successful, but nobody can 100%. But at least we try. You know? The thing about settlement is very much hinges on the party's desire as well. If one party have no desire to settle, it can talk 8 hours, and talk 2 days, 3 days, it makes no difference. But if they want to settle, the two parties settle, believe me, it can be settled. At least, if not 5 issues, you can settle 3 issues. And in the settlement agreement, you just note that 3 issues has been settled, and the 2 issues will be referred to arbitration or referred to court. And one commercial mediation by done, shareholder dispute, actually they were overset. They want to have another meeting, another mediation session. This is at their request, both parties' request, because they know there is somewhere there. But true enough, the second time we have mediation session, they settle. And this because they want to settle. Mediators cannot impose a settlement. Let's be clear about that. It's not the mediator's role to impose a settlement. The mediator's role is to get them to realize on their own that it's best to settle. It's for your interest. It's for your, all right. So, in short, summarize, mediation process is actually a form of evolution of dispute. Here is the mediation session. Why are they here? Because of something happened in the past. All right. But what is the aim? Is to move them to the future to achieve a settlement. In a lot of cases, with mediation not done properly, you'll find that the parties here will talk. But they always go back to the past. You were like that. You know, I don't trust you anymore. That is a very toxic words to use and very damaging for a successful mediation. So the mediator must take note of that. I don't trust you anymore. So you got to deal with that in the private session. Why? You know, can we talk about it? Can we do it this way? That at least agreement about visitation rights of the child is done in clearer terms, you know, twice a week, twice meaning Saturday and Sunday, and not from 9 a.m. to 10 p.m. Very, very clear, so that the wife trusts that this can be implemented. Rather than, I don't trust him anymore, he will never follow this thing. So no solution. So it's very important that don't always go back to the past. Mediators is to get them always to the future. That's why we use the term options, generating options. And that's why we use the term settlement agreement. Move towards that. So that's the kind of round summarize what is mediation and the advantages of mediation. Basically, it's private and confidential. And statements made is without prejudice. Time definitely is time saving, 1 day, and can be scheduled within 2 or 3 weeks, because it's up to the parties when they are free to mediate. And on the most, as I said, most of my cases is actually 1 day only. In fact, even the bar councils, AIAC, all they all scheduled for 1 day only. Then just to summarize, mediation process is the control of the parties. Mediators don't make decisions, it's the parties. So then even the terms of settlement is the disputants. Is there somebody want to ask question? Online. Okay. All right. Now, the important thing is creative options. I already give you some examples that is not necessarily confined to the 4 corners of the contract. That whether there's a breach of clause 27 of the PAM contract, it can be many ways to settle. Then the 5 is win-win. That is the idea. And settlement agreement is voluntarily. The terms of the settlement is by them, so it's win-win. And at the end of the day, there is always opportunity to preserve the relationship, no? If you done in a proper way. No? And flexible and made for you that it can be done in any time. It can be done in a hotel environment. And frankly speaking, we don't talk about evidence and law. In a real mediation, we actually ask the parties to give us 3 pages and some basic documents. So the most you have is that's all for the mediator. Not like arbitration where volumes and volume. What we want is just the basic nature of the dispute, and we go through and discuss the problem. We don't look deeply, not to say don't at all, into the evidential part of things. The basic one would be like prime contract, letter of intent, and the complaints are that the main contractor have against the developer. No? This is what we look at basically. And non-adversarial, I think you know what I mean, right? Because you are not subjected to cross-examination. Those of you who have been to court or seen movies, can you imagine you're being cross-examined by your opponent's lawyer? It's not nice to be there. They pin you down. Yes or no? Why you said that now you said that this? No? Not nice to be cross-examined. But in mediation, no such thing. And again, it's neutral and no decision-making by the mediator. And here again, disputants are encouraged to speak freely, tell their stories. And in fact, we actually, in the preliminary pre-mediation session, if the lawyers are present, we actually tell the lawyers, this is a process and we will encourage your clients to speak more. And nothing disrespectful, but this is a process for the parties. You can still be there, but your role is more of an advisor. We won't have sharing food before and during mediation. No problem with that. So I'm just quickly summarizing what I said just now. All right. You want to just tell us, I'm going to tell you a story. Of course, this is not nothing to do with construction, but there's something that for you to ponder, all right? It's what we call sexual harassment in workplace. As I said, mediation can work in all kinds of disputes. All right. Let me go through quickly. Shida is an attractive 28-year-old single woman from Penang. She worked as an accounts executive in Fantastic, and 4 months ago was transferred to the company's main office in Kuala Lumpur. She reported to Haris, a senior accounts manager with Fantastic. Haris has a very jovial personality and is friendly with all his staff. 2 days after Shida started work in KL, Haris started hitting on Shida. He told her lewd jokes and had a bad habit of touching her when talking to her. A week later, while working on an assignment together in the evening, he started putting his arms on her shoulders and told her how beautiful she was and asked her out for dinner. Shida politely said, no, thank you. But Harris persisted and kept asking her out on several occasions. No one in the office has witnessed any of these incidents. But things changed after Shida declined his last invitation. Harris started to criticize Shida's work and became demanding. A number of Shida's major accounts were unexpectedly reassigned to other accounts executives. As a replacement, Shida was given trivial assignments. So Shida felt angry, depressed, and humiliated. Shida complained to the HR manager, who was skeptical and thought that Shida was over-dramatizing, and further commented that she should be able to take a joke. Shida quit her job 2 months ago and commenced legal proceedings at the Kuala Lumpur High Court, seeking damages from Harris and Fantastic for sexual harassment. And this is data from my co-trainer, role play. Although it's not a construction contract, but it is a dispute which you all may have heard about it in your daily lives. Maybe when you all were employee at the time, you may have heard about it. The question that I ask you is, what will happen in court? Legal proceedings in court. Can you imagine? The Shida have to sue, and sue not just Haris, also sue the company. Right? I think you know that these two persons are liable to be sued. But what happened in court is you have to prove, Shida had to prove sexual harassment, that such an incident happened, the kind of thing. Not easy. And probably she may have a colleague who can support her. Not so much support her in the sense that Haris did that to me before. But she had to get that. If that colleague of hers is still working there, will she come and help her? Probably not. You have made with an ex-colleague. But to get the ex-colleague to come to court, she has to take leave. So many things that she does have to encounter. Of course, the most important, the obvious one is legal fees to pay to your lawyer. The company, of course, how to defend it? He will say, no, but it will be dragged to court. And assuming that, I think some of you may have heard about this Me Too movement, right? In America, in Korea, everybody else, more and more people are willing to talk. So can you imagine the boss, fantastic, will say, oh, what if somebody else come and testify in court and Haris did all these things? And very common, Haris, or rather the boss of the family have heard that Haris is liable to do this kind of thing. So all this will become a matter in court, but how the judge going to decide? Very difficult. So these are the cases where mediation comes in. Because in mediation, number one is private. So the company's reputation, especially Fantastic, is preserved. And you are the boss of Fantastic, you will want it to be private. Number two, Haris. Is Haris so clean? Probably the boss have some information from other sources in the company that Haris have done certain things like this to other employees, but don't want to be known to the rest of the members of the public. So, but that is something which he can use to get Shida to settle. And if Shida settle, probably some kind of financial nomination, or if she needs a job, what is other form of settlement that Shida have? If she needs a job, and she can go back to Penang. There's a branch there, right? Away from Haris, because her main problem is Haris. So the options of settlement is that she goes back to Penang and work in the branch there. Same job, same salary. Her problem and her concern has been taken care of by having this kind of solution, but not in court. The court cannot say, I hereby order that Shida goes back to Penang. No way. So mediation in that sense is a very different kind of approach towards dispute resolution. Many creative ways you can do. Okay, this is one example. All right, I'm moving on to another topic, but before that, anybody want to ask any question? Sorry. Contractual agreement. Okay.
Oh, online. Okay. In the event that both parties, after the mediation process, they have agreed and then they have signed an agreement, okay, settlement, all right. But maybe after a few weeks, either party, maybe we want to rescind the contract agreement. So what effect would that be to the agreement? Is it legally binding?
Thank you. The question is, the settlement agreement arrived at by the parties, and later the one of them don't want to comply, is it legally binding? What can be done? The answer is the settlement agreement is binding. In that kind of situation, you can go to court and enforce it. For example, the agreement was to pay me the balance 100,000 in form installment. It did not, then I can enforce it. Right? I will come. There's one slide actually on the point about it's actually also provided for in the Mediation Act, the Act of Parliament, where it clearly says that settlement agreement is a binding agreement. Hope I answer the question. Any other question? If not, okay, I'll move on. Basically, what I'm going to share with you. Oops. Yeah. Is what I will call it as some skills of a mediator. The reason is because I want you all to really understand not just what mediation is about, but what to expect from a mediator, because you're getting the person to help you to resolve it. So the mediator must be someone who has the skill of helping you. And these are the skills which actually we will explore in our workshop. No? So that, and things that we call it the principles. No? Participants are problem solvers. We actually tell the mediator, you must not see the disputants parties as a bunch of nuisance. Can't they resolve things themselves? Why, especially neighborhood fight, the kind of thing? No? Why are they quarreling over it? You know, small things that are so petty. No. Respect them. They are problem solving, meaning to say that they can solve the problem themselves. All right. So this is where the mediator must have the kind of mindset. Decision begin with exploration of problems and educate one another about the interest and need. This is what the mediator needs to do. Mediators must have the skill to separate the people from the problem. All right. So you can be soft on the people but hard on the problem. Basically, it means that you are always late. But what is the problem? Time compliance. You want the employee to come on time so that the work can be done. So you actually talk and resolve that problem. You notice come late. What's the issue? Oh, I have to send my children to school. No? Okay, is there any other way we can accommodate it? Or maybe we talk of flexi hours. Instead of coming at 8:30, I come at 9:30, but finish at 6:30. So what happened? I'm transforming the dispute into what I call the problem is not you. You're always late, that kind of thing. All right. And this is where the mediator needs that skill and need to build trust. Then the other skill of a mediator is to get the parties to focus on interest. That's where I mean, we don't really look at the four corners of the contract. We really listen and want to know what is it that bugging you. No? And we also underline interest. Underlying interest in the sexual harassment case, as I mentioned, actually, Shida wants to work, but she just cannot stand this harassment from Haris. So you take Haris out of the picture, Shida's underlying interest and concern is taken care of. Who knows? The boss may say, Haris, and I transfer you to the Ipoh office. Things like that. But of course, example I give, Shida transferred to Penang. That's another option. The other skills in mediation, which is very, very important, is what we call active listening. People will think that I'm listening, but you just behave and pretend that you are listening. But as the skillful mediator believes and practice active listening. This is, in a way, summarize the whole meaning of active listening in a Chinese character. Some Uh, I'm not a Chinese educator, but somebody shared this with me, So those who don't know Chinese may know. This is an old version of writing a Chinese character for ting. Ting is listen, right? Ting. But you listen in the way the Chinese character used to describe ting. You think with the ear, correct? Not this right? But you also think with your eyes. And you also think with your heart. You listen with your heart. I mean, you think with your heart, you listen with your heart and undivided attention. So it's a very encompassing kind of skill. You really have to listen with your heart and eyes and not just the ears. All right. So this is actually we teach that in our workshop. Reframing is another skill which we will teach the mediator. And basically, we reframe the issues, the narrative, so that you can keep the dialogue going. And by reframing, you remove the problematic parts of the message, which could be a threat, and you change the perception and interpretation of the situation. All right. So these are some examples of what we mean by the skill of reframing. She is a liar. I don't trust her. All she does is make empty promises. So how can I enter into an agreement with her? Right? You mediator reframe it. So you will need safeguards to be built into the agreement in order for you to be sure that it will be carried out. This is what a mediator should do. Move them away from a positional thing of trust. And her position is, how can I enter an agreement? That's her position. If you leave it at that level and the mediator don't deal with it, there's no settlement because she just don't want to sign. But a skillful mediator will say, okay, let's talk about safeguards to be built into the agreement. What is it? It could be an issue about payment schedule. It could be an issue about delivery schedule, timing, and about checking about the quality or this thing. Let's build into the agreement so that her concern can be dealt with. So what is happening is the mediator is getting the parties to focus on safeguards, but implicitly and behind the discussion of safeguard is to get them into an agreement. Move them away from this position. I don't want to enter an agreement into a position of talking about the agreement, the content of the agreement. So when you talk about it, the mindset is changed. We use the term less positional. Don't want to sign to a situation of less. There is a possibility of signing, but what is it? Okay, this is what I call reframing. Huh? I talk about the lateness of this thing, as example. So I'm not going to that. The other skills, this sorry, I'll just be very quick on this topic because it's a it's a 5-day workshop that nobody we have to talk about all these things. But for today, the other skills which we want the mediator to have is questioning skill. Able to ask the right questions at the right time. All right. So I think you know that this is the usual how, why, what, where, and when. So then actually we categorize two types of questioning. One is called open questions, like what is on your mind? What do you think of his offer? When is the deadline? No? All these are open questions. Then we have what we call closed questions. Do you send the list of defects to the architect? Usually yes or no answer. All right. But you have to interplay, mean a mediator, between closed question, open question, closed question, open at the right time. Can you imagine that the two parties are in front of you discussing about settlement? Then you say, what happened to that incident in the kitchen about the harassment thing? what are you inviting the person to answer? In this kind of open discussion where the other party is there, it's very embarrassing to talk about that. No? So you keep it, that kind of question, in the private session. So a good mediator knows all these things. Finally, the role of mediator, I've gone through it before. I will skip it. All right. This is the one I mentioned about the act. It is a law in Malaysia and called the Mediation Act 2012. I was told that to finish at 11:30. Yeah? Is it okay with you all? Then after that, we have 15 minutes of 11:30, right? Okay. I'll try to finish 11:30. Okay. I'll basically just highlight one point on it. That's all. It's in the act itself that it says that the mediator must be impartial and should not be affected by personal interest. It's also in the act, what do you call this one? As one of those participants mentioned, Section 14.1, a settlement agreement to be binding on the parties. Clearly mentioned that. And settlement agreement to be recorded as consent judgment, assuming it's in court, and agreement to be enforced contractually. All this is safeguarded in the act itself. Yes. I think we go in that sense. The question by the gentleman is that can the terms of the settlement agreement be different from your contractual agreement, contractual rights in the agreement? The answer is yes. All right. It's, for example, even things like LAD, instead of $1,000 per day, there's you can say, okay, I only pay you $100 per day. Because of the nature of the event, could be because of COVID or because of hurricane. No problem. Right? So the short answer is that no problem. Only, all right. Yes, you see, depend on the nature of the settlement. If the settlement agreement, they say, has already covered LAD in the settlement agreement, so there's a dispute and it's a case of one party not honoring it, then you go to court to enforce the settlement agreement. But if the settlement agreement did not touch on other things, for example, the defects liability period, which is, they said, and for some reason it was left out in the mediation, it doesn't stop you from going to court to deal with the issue about the defects liability period, including what they call the performance bond and all these things. This is my own timer. Okay. So the answer is yes, you can go to court either to enforce the settlement agreement or go to court on other issues, which is not. And settlement agreement, you see, because unless you are something which is not quite within the settlement agreement, then you can go to court on other matters. Otherwise, the act allows you to do that.
Ongoing, can you can you get the mediation process to go on concurrently?
Definitely, yes. And the courts in Malaysia are very, very supportive of mediation. If you tell the court, can we postpone the hearing because parties now want to mediate, the court in Malaysia are very, very happy to do that. And so even mediation can be held halfway through the trial. No problem. Anytime, actually. In fact, there's one mediation done in Malaysia by this judge, Loh Ho Beng, in the Court of Appeal, where it involves the custody of a daughter, a child, whether go back to UK or not. Even the Court of Appeal. So mediation can be done at any stage so long the parties wants it. All right. Another question?
And the judge can say that I want to see the settlement agreement before you come to the court. Can the judge?
The answer is no. Concurrent. The judge cannot impose and say that I must see a settlement agreement. The judge can encourage parties to go for mediation. And in fact, in Malaysia, the last 15 years, the court have evolved a mechanism called the court annex mediation, where they themselves ask the party to go for mediation before another judge, before a registrar. And they give a time frame, they say within 3 months to sort it. If not, come back to me and I'll fix a hearing date. And in accident cases in courts, I was told by one of the session court judge, 90% it goes for mediation first in what I call running down cases. So the correct answer is that it goes hand in hand. Yeah, it can happen, but most of the time, okay, they say the judge would not what they call finalize the thing when the mediation is going on. They will ask for a report. That's why they give a 3-month time frame for parties to resolve. If they can resolve it, then the settlement agreement, usually, not all the time, will be translated into a consent judgment. And if it equally more powerful than a settlement agreement. Because a consent judgment has a different mechanism of enforcement if, as you said, one party don't want to honor it. So not a problem. But for some reason, there's a judgment and then parties still want to mediate, it can be done. Can be done. But the mediator should be informed that there's such a judgment so that your concern about contradiction between the judgment and the settlement agreement can be resolved by the mediator. If the mediator doesn't know, yes. But the best way is let the mediator know that I already got judgment, but parties still want to settle. So the settlement agreement will be whereas parties have commenced this case in the High Court of Kuala Lumpur, and the parties have, and judgment have been entered in favor of the defendant by the judge on such a day. Both parties, plaintiff and defendant, hereby agrees to, you can use the word vary the judgment, or to not to comply with the judgment, but to follow the following terms and conditions of settlement. Right. So that will remove any contradiction that arises between the judgment and the settlement agreement. So it all depends on the mediator, whether he is aware of this thing.
And they mediate. And if the mediation result varies from the judgment, is it acceptable?
The settlement agreement, the question is, if the settlement agreement varies from the judgment, it can be acceptable because it's mentioned in the settlement agreement. Then, okay, maybe I explain a little bit about litigation. This is court at the end. A judgment is at the end of the day is win or lose. All right. So you can have a situation where they appeal and they got stay of execution. So nobody's got anything. So in that sense, you can have a settlement agreement after judgment to try to resolve the parties. For example, payment. Who knows? Then that's why they said the way you word the settlement agreement is very important. So as I mentioned, the example I gave, you have to mention in your settlement agreement that was such a judgment today. Parties now hereby agrees to vary the judgment in the following way. Not a problem. So become a contractual agreement to vary the judgment. And you get is in the law, as the law, it is binding. Very good question. Very good question. Luckily, the government is sympathetic to mediator. It's in the Mediation Act where it says that the mediator cannot be sued unless, of course, there's always unless it's misconduct or fraud or that kind of thing. No. But cannot be sued. And we cannot even be subpoenaed as a witness. Only in very, very exceptional case.
Yeah, in the mediation is very important. Make sure that you cover all the scope, and whatever scope all covered. If just like what happened in the court line, unless there is different terms, then mediation can be what I call this an assistant to the judge.
Not so much an assistant to the judge. For example, or if the parties don't want the judge to know. So in that way, neither party can even disclose to the judge that we have agreed on AB, but the rest go to court. All must be by agreement. And one of the important things about the mediation process is that it is a party who agree among themselves to the terms of the settlement. What a mediator needs to do is to ensure that the points are all covered. All right, but at the end of the day, it's their decision. They voluntarily willing to settle. So the chances of we going to court and we dispute is much less. Not to say 100% guaranteed, much, much less. And this is where the beauty of mediation is all about. In the sense that, look, why need to go to court? So acrimonious, and so much time wasted, so much cost, when it can be settled within 1 day. And to talk about cost, just let me share with you. The many depend on which organization you go to, because Bar Council, MIMC also have mediation, the AIAC also have mediation, I think PAM also have mediation. They all have different scale fees. Bar Council is up to you to negotiate with the mediator. AIAC also negotiation, but the minimum is 5,000 per day. Per day. So the two parties is 2,500 only per party. But the matter can be resolved within a day. And I tell you, many other countries, even Malaysia, 70% or 75% success rate if the parties want to settle. So much time saved, so much cost saving. So it's really a wonderful thing. I don't think I will have time to go to the rest, but I just thought I can take more questions and then we can end off the session. Is it okay? Quite a lot. Okay, just now what I mentioned is about this settlement agreement, right? It's pending now. Okay, this is the one which is I mentioned about mediation communication is privileged and not subject to discovery or admissibility in evidence in any proceedings. So you have a statutory protection about confidentiality. Very important. Because there's some exception, but this is, I will not, I mean, it's actually basically, if it's used to plan a crime or this thing, you cannot say that I cannot divulge to the judgment. This is a normal case also about privilege. Okay, I actually have one chapter on this, but you're going to take another 10 minutes, the role of lawyers, but probably I will not go into it, just to make a very general comment, which is, yes, lawyers can be present in the mediation. In some cases, they don't encourage lawyers, but we do. Number two is the lawyers must also understand the role in the mediation. That one, I can frankly tell you, I am a lawyer. We have a bit of a problem trying to convince our own lawyers to embrace mediation and to behave as a true advisor in mediation. If a lawyer is in mediation, we actually, in our lectures to lawyers, please do not behave like you are in court. That's why, in short, that is our message to the lawyers. But there are a few what they call slides and all this thing where we actually tell lawyers that, look, help the parties to come to a settlement. Do not add more fuel into the whole thing. but you are there as advisors on the law. As to the settlement, let your parties decide. For example, between 300,000 and 200,000, don't think lawyers should meddle with that. You know, because it's just a figure of commercial, what they call commercial terms. Let the parties talk about it. Some lawyers said, no, don't. It's too low a settlement. I mean, it can happen sometimes like that, but the idea is you as a lawyer in mediation do not behave as if you're in court. So this, in short, will be what they call the process of the role of lawyers. And especially we remember the pre-mediation, we mediators also will tell the lawyers that not to behave, because we don't use that kind of language. Don't behave like you are in court. We use it more nicer words. Okay. So, I mean, in the mediation process, this one thing we normally will, we ask the mediator to treat the mediator as a collaborator, not an adversary. You know? This is something we call a mindset change for lawyers, the court-going lawyers. They're so used to seeing people as adversary in court, you know, and they will want to try to convince a judge to take a certain opinion in their favor. But in mediation, the mediator doesn't give opinion. The mediator is neutral. So we have to advise the lawyers, please, no, see us as collaborators to achieve a amicable settlement. Don't give me all the laws. How many cases to us, we don't make opinion whether the law is right or wrong. Okay. All right. This is what I have to share with you what mediation is about. And I hope that what I call you have some idea. And basically, my message to you is mediation works. What is needed is for you to understand what is mediation, what to expect. It's not like a pasar malam kind of situation. So there is a process, and an effective mediator can help you all to resolve it. Here, I just want to spend 2 minutes only on this, is to let you know the development of mediation around the world. The United Nations General Assembly, sometime in 2018, have in fact endorsed this Singapore Convention on Mediation. So the world is embracing mediation now, to the extent that they, in fact, getting international community. And people who have ratified it are Singapore. Malaysia has not ratified it yet. Other countries have. Working on it. Working on it. The person I talked to is working on it. They're talking about it. Yes. And the thing about the call, it started in 2020. So that is, this one is what they call maybe not up to date yet. But that to show that United Nations is actually getting very keen on this. And in very short, very briefly, what is this Singapore Convention about? Is that international dispute resulting from mediation concluded by the in resolving commercial disputes. So you can actually go to international tribunal to resolve disputes which arising from mediation. And also to seek an international mediated settlement agreement. So I think the answer one of the participants, whether mediation is binding. Of course, not 100% that parties will comply with the terms, but at least you have a mechanism to enforce it. That's the arbitral award. So United Nations have embraced mediation and now created a forum to enforce an internationally mediated settlement agreement. So in that sense, don't be despair that, I signed a settlement agreement, but I can't enforce it, And of course, you have this Malaysian International Mediation Center, which was actually it was launched by the CJ recently in January 2024. Again, Malaysia and the judiciary and the Bar Council are moving towards mediation and want to promote it. In a way, yes. Okay. I think the original name of this organization, which is set up by the Bar Council, is called the Malaysian Mediation Center, MMC. So recently they want to internationalize it, mainly because there are so many cross-border disputes. So they want to make it more acceptable to even foreign parties. So they use the word international. That it's just like the KL Regional Center for Arbitration. Now they change to AIAC, that kind of thing, to give a more international image. Okay, and I'm gonna. All right, that is more or less my lecture. But before you go, I just want to ask you to look at this. What do you see? Who see a vase? Raise your hand. Who see a vase? Raise a hand. Okay, who see what I call two faces? Right? Good. This one, what do you see? Who see the word optical? Who see the word illusion? Right? So those who see the word optical and the other group who see the word illusion, are they wrong? Believe in that both parties can be right. If you are a mediator, believe in that. That's why it's a question of perception, how parties look at the dispute. You can get, meaning a mediator can get them to look at things in a different way. They will see the dispute in a different way, also from the other person's side. And because of that, they will mellow down. They'll be less resistant. They'll be less positional. And they'll be more willing to come to a settlement, which is amicable, which is all agreed to by them without any imposition by the mediator. All right, so that concludes my talk. And last one, for those of you who are bosses or this thing, just take note of this. Choices made in anger cannot be undone. Okay, let's be careful with that. Okay. Answer is anybody, so long you have undertaken this course. Just now, during the break, Ken was sharing with me that he is also involved in ADR center, which includes mediation, and he himself also give training. Our side, we give 40 hours of training. That is the minimum requirement internationally. But we have an assessment at the end of it. So you can pass, you can fail. Once you pass, then you have a certificate. The certificate is issued by various organizations depending on the trainers or depending which workshop you go. You have the AIAC, which is also give training and certificate. And in my case, I work with the University of Malaya. We also issue certificate. And of course, the Bar Council also issues certificate. So anybody can. No. In fact, in other countries, they are promoting what they call community mediation, which Ken is a group is doing that. And that community mediation, in fact, it encourages neighborhood. People who want to be mediator, like for example, in Malaysia, we have Rukun Tetangga, right? And members of the Rukun Tetangga can be, but must be trained. Otherwise, they'll give mediation the wrong image. As I started off by saying, look, the way that people pursue, how much you want to settle? You agree or not? You see? No. So the mediator don't know what to do. Yeah, physical punching happens. Especially in the family dispute. Physical violence can happen. Sorry.
The role of justice of peace and the mediation, actually, of course, now there aren't many JP being appointed, but are the role same thing with the mediation?
In a certain way, yes. The justice of peace is also help parties to resolve issues, right? In fact, as I mentioned in the earlier slide, even for example, the clan association, all this thing, actually it's happening now, even in the Indian community, all this thing. The question is, when you talk about commercial dispute, there is a different kind of a skill required. Otherwise, it can be just be there in court or arbitration or things like that. And I think modern world evolved where a lot of commercial contracts, a lot of commercial disputes. Not to say commercial, even geopolitical disputes can be resolved. Remember the Aceh in Banda and Indonesia, Aceh? Dispute between the Indonesian government and the Achinese separatists. It was through mediation that they came to a settlement. And now it has been quite peaceful for about 25 years already, in that sense. So it's the skill of mediation that I need to emphasize. That when we go through the training for those who are interested, and if you go before a qualified and trained mediator, your dispute can be resolved. 75% success rate if you want to, you are willing to resolve. It's a matter of getting you all to talk to each other and come to a settlement. You mean the fees? Nope. No quantum. Oh yeah, in mediation, anything, no quantum, no limit, no what they call restriction. It can even be what they call dispute between a group of people like the Penans of Sarawak and the timber company. No? All mediation, but the focus, of course, is commercial mediation, and there's no limit, no amount. Unfortunately, if you follow the AIC scale fees for mediator, it's still 5,000, even though the amount could be a few million. But that is, of course, the minimum. The mediator can negotiate for higher fees. The actual one is 1 day. 1 day. In my case, 9 o'clock to 5 o'clock. But it always towards the end, the parties want to settle. And I actually have 2 cases, but it actually went on to 6:30. And this one very fun. I must share this with you. It was from 500,000 and 50,000 gap now. So how to resolve? But finally, find something, it was resolved. So we get them to sign the settlement agreement, which is usual because it's a court case to record a consent judgment. The settlement agreement basically says the defendant shall pay the plaintiff, let's say X amount within 2 weeks, or within 1 week, I think. And then the parties will record and the consent judgment and withdraw the case. So it was how it was worded. You know what happened? The defendant said, no, my checkbook is in the car. I go downstairs now. Go on downstairs, really, to the car park. And we waited for 10 minutes when they come out, bring the checkbook and sign. That's it. Because it's amicable. No need to think about 1 more week or 2 more weeks. I agree with you. The other side agrees. So sign it. That is true story. It's just a matter of getting parties to talk to each other. All right? Well, the one that I've done is shareholders dispute. Then you have estate, Then construction. One I think was the developers and the not squatters, they call it the ground tenants situation, developer ground tenant, JVs, kind of thing. So it varies. But there are what they call specialist mediator who are focusing on matrimonial cases. And it does require a different kind of skill if those want to do matrimonial dispute cases, no? And there are actually called advanced courses for those mediators who want to specialize in those areas. And it's a very beautiful methodology to get people to actually solve the problem. And mediation is, to me, so beautiful when it comes to matrimonial cases. Really, really. I mean, really so acrimonious. Children are affected, all these things, but through mediation, it is the best way rather than go to court. I think should any mediation involving architect? Answer is yes, you should have. Although I personally have not done involving architect, you know? But I'm not surprised that there will be lah. No? Oh, definitely in court. Definitely you have parties where involving architect is suing or architect being sued. No? But mediation, I myself have not done any involving architect. But I'm not surprised that there will be cases. And again, it is suitable.
No, is there anybody, based on your experience, taking this act, abuse it and then for their own benefit?
Whether anybody have abused the Mediation Act for their own benefit, my own personal experience, none. And I have not heard of anybody who abused it. The only one which is actually went to court where one party didn't want to settle. This one is a court case. I said, I didn't know two, one only. The judge was very, very supportive of mediation and said that this is privilege, confidential. So we need that kind of support, and we are getting it from the judiciary and the judges. And the only thing is, it must go beyond the court arena. As I mentioned about court annex mediation, right? It's getting very popular now. But people like you all, members of the public, commercial people, all these things, professionals, embrace mediation. It is really a better way to resolve your dispute. And it can be done. It can be resolved.
Developer and contractor, you go to SIPA and going to the mediation. Which one is faster? And which?
Hello. Oh, the question is between SIPA and mediation, which is better? All right. Okay. I myself done SIPA as well and mediation. Okay. All right. So I think SIPA, hello. I think SIPA have come a long way to help the parties to achieve some kind of resolution of a claim in a much shorter time compared to the old way of arbitration. Arbitration, I think you all know, like, it's supposed to be faster than court, but a lot of cases, court proceedings faster than. Because it's like a summon. I SIPA you. And there's no choice but to go and defend it. But in mediation, we focus, and in fact, that is the true meaning of mediation, is voluntarily. So if one party do not want to settle, in that sense, time-wise, SIPA is faster. No point that please come mediate, no? He doesn't want. So, but if the party willing to settle voluntarily and come for mediation, mediator can help the parties within a day, as I said. And preparation, 3-4 pages, that's all we need. And some basic documents, that's all. The rest is talking, the rest is understanding each other. And 75% success rate in Malaysia. Hope I answer your question.
SIPA can be a summon also, right? Say, for example, the contractor claim against the developer, and then developer refuse to pay, but based on the architect certificate issued, they just go to SIPA and then they want to settle that. It can be one-sided, right? And mediation, you need two party voluntary agree to go for mediation, right?
So definitely the answer is correct. No? You need two parties. Of course, the cost implication is different. For example, SIPA, as you know, it depends on the amount of your claim. Then you have to pay first. Usually the claimant will claim against the other side, usually against not developer, but subcontractor and the main con, they will claim. No? But there is a fees to be paid. And it's becoming a little bit of a issue in the SIPA world, is that the claimant had to pay his portion of the adjudicator fees and the AIC fees. The other side also supposed to pay, right? So starting very nice, both parties have to pay. But in reality, I personally have also encountered it. Towards the end, when the adjudicator want to make a decision, the respondent don't want to pay. All right. And there's nothing you can do to compel the respondent to pay. So invariably, the claimant had to come up first. So depending on your claim, it could be 20,000 or 40,000 adjudicator fees, right? So you pay your portion, let's say 20,000, but the other side don't want to pay, so you have to fork out your money first to pay the adjudicator fees so that our adjudicator can come up with a decision. But you do not know whether the decision in your favor or not. So in a way, as I said, the SIPA world have evolved to this situation where the claimant had to pay first. Oh, because it's voluntarily. As I said, we cannot compel the other side to come for mediation. But because he's willing to, very likely, in fact, more or less, he will pay his portion of the mediator's fees. Because if he doesn't pay, that means he doesn't want mediation. That means no go from day one. Unlikely. Of course, the delay of time is always a mechanism where one party don't want the matter to resolve fast. It always happens, even in court, even in adjudication, or even in arbitration. When one party just delay, that one is human nature. All right. Thank you for hearing me, and I hope you have some taste of what mediation is all about.
Thank you to Mr. Chia, who shared the expertise with us today. To show our appreciation, I would like to invite Architect Chong Kok Chong to present a souvenir to Mr. Chia.